Hello and welcome. My name is Brendan Cody. I'm an attorney in St. Paul, Minnesota, and this is Josh Stoka, my guest with Archigo and Stoka Law Firm. Josh specializes in workers' compensation, and his partner as well does criminal defense. We're here today with another episode of Think Like an Attorney, the podcast. We want to welcome you here today. First and second, if it's not too much trouble, please feel free to subscribe and like our episode if you do enjoy the episode. Today's episode is entitled essentially Best Damned Law School Stories, period. The idea here is to give you a couple, actually four of them, law school stories from law school classrooms that we have both had the luxury and been able to learn from in terms of law school situations with classrooms and with professors. Typically, I'd like to start with the story that I have is that, and I'm going to give a preface here, when we talk about law school, the idea is it's a whole lot different than college. It's a whole lot different than high school. Regarding law school, you had to be prepared for every single class. Typically, you may have to read 100 pages for one particular class. Why do you have to be prepared? Because you may be called on by your professor. And at any time, your number can come up and you're required to recite a case. If anyone's ever seen the movie The Paper Chase, that shows a classic example. The concern I've got, Josh, and I'll just bounce this off you before I tell my story, is that I'm hearing now that students in this day and age are in law school are getting a pass from the professor if they don't want to recite a case, that they don't have to recite cases. Have you heard much about that?
A little bit. I think each professor kind of does it a little bit differently. Some allow a pass, some don't even do the Socratic method anymore. Some are still pretty strict about it, but I think they give them a lot of leeway in how they do it. So, but I think it's shifting away from the Socratic method and being really strict about having to recite a case if you get called on to allowing a little more leeway, which I don't really necessarily think is a good thing.
I am in full agreement with you. And just to walk it back a bit, the Socratic method is named after Socrates, the great philosopher. And the idea is that we reach the truth through questions. And the professor will ask you questions back and forth and try to box you in and corner you, and you really have to think on your feet. And I think it's important to develop the mind of a young lawyer, even before they become lawyers in law school, to be able to speak in a courtroom without notes and to speak in a courtroom kind of off the cuff and thinking on your feet.
Well, the fear of being called on is part of the reason that obviously you want to learn about the case, but that fear kind of puts the idea in your head, okay, what could he ask about this issue or this fact? So it trains the mind to start searching for questions, which is the whole point.
And it also trains the mind when in law school, is to train the mind to be ready. I mean, you had the fear. The worst word, it's the U word, unprepared. You do not want to ever have to say that to a professor. So here's my first story. And I was in property law, my first year of class, and we had an assignment due on legal research and writing. We had to write a brief. And essentially what happened was I had worked on that brief very hard, and I was not ready for property class. So what did I do? Took the bull by the horns. A couple hours before the class, I went to my professor's office, spoke with him and wanted to see him. He was there, thank goodness, and I spoke with him and said, look, I have to tell you, I don't like being unprepared. This is not a habit. It won't happen again, but could you maybe not call on me because I had to do this project? And he says, what was your name again? I said, uh-oh. And then I gave my name again for a second time, and then he looked in his attendance book, gave me, he looks at it, oh yeah, Mr. Cody, yeah, right here. I got it. I will not call on you. And I said, boy, I'm thinking this just is not sinking in. Anyway, so I did what I could. I go into class a couple hours later, feeling pretty confident, feeling like I'm probably going to be okay. I won't get called on. And sure enough, he cites a case. I think it was like Pennoyer versus Neff, some great case. And he says, Mr. Cody. And I look at him, he looks up from his assignment book or his attendance book and looks at me, and we lock eyes, and then I raise my hand. He says, "Oh, I'm sorry, Ms. Cohen." Holy cow. This was incredible. This was unprecedented. This was a situation where there was an audible gasp in the classroom where everybody's thinking, how did he do that? Why is the teacher essentially apologizing to a student for calling on him? This is unheard of. And I remember I walked a little taller that day among my classmates because they thought I had something that it maybe intimidated on some level the professor. A couple things and the lessons on this. And the lesson is perception is reality. I was completely unprepared, but people thought that I was somehow a little bit better and above being called on. The second thing is that poor Miss Cohen, who he called on next, there's injustice. That's the other lesson. There's a bit of injustice when it should be just. It's injustice because she had to cite a case that she never would have had to cite because of me. So the idea is that perception's reality. Our image is really important. Your reputation is very important. Your reputation precedes you, whether it is merited or deserved or not. So that's my first story. Josh, why don't you give us a story or two from law school?
Well, this story's kind of in the same vein, actually. So nearing the end of each semester, you're kind of caught between two hard places. You're caught between having to study for finals sorry, and still reading the cases. So you got to allocate your time a little bit better than you normally would during the semester. And some students choose to just study for finals. And I'll go to class, learn about the cases instead of actually reading them. Well, we showed up to a civil procedure class one day, and he called on the first person, just kind of said, I have not read this case. So he's like, okay, I'll go to the second person. But he makes a little note in his book about who didn't answer the question. Second person, sorry, I also didn't answer the case. By the second semester, you're kind of just being honest with the professors instead of trying to wing it. So everyone's just saying, I didn't read it. So the third person, he calls on them. They say, I didn't read it either. He just grabs all his books, walks out of the room. He's
No.
like, he's like, I'm done. If you're not going to be prepared, I'm not going to be prepared. And he just walked out. Everyone kind of sat there for a couple minutes and like, okay, I guess he's not coming back. Let's just leave. So, the next class, he didn't say anything about it. He just proceeded on to the next lesson, but we all had to learn those cases on our own. And, everyone who didn't read it kind of assumed that they would learn about the case at class, which obviously didn't happen. I think all of us kind of learned our lesson. And, you take a gamble every time you go to class and you don't read a case. So he made us pay the price, and I think obviously the lesson is kind of what you said. You've got to be prepared for class. Even if you're allocating time towards studying for finals, at least make a cursory read of the case, make a few notes about it, so you can at least say, I read it, and I have a couple things to say about it, versus just saying, I didn't read it at all.
I think that really resonates with me in that the good old-fashioned shaming, I think, is important in law school, because otherwise you have no standards and judgment-free zone. We don't need this judgment-free zone crap. What we need is good old-fashioned shaming and making you accountable for those materials and being ready. I mean, are you going to appear with your client and tell the judge, I'm not prepared at trial? Are you really going to do that? Because I can guarantee you a judge will not give you a pass in that regard in his court.
Well, some of the students were like, we pay good money for this class. He has no right to leave. The rest of us were like, he's exactly right. He's like, I'll give you 3 chances. Otherwise, I'm out of here. If you guys aren't going to take this seriously, I'm not either. So I don't really blame him for doing it. He taught us a valuable lesson that day. So maybe that was the lesson. He actually did teach us maybe more than he did he would have if he would have just gone over the couple of cases we're supposed to learn that day.
That's amazing. The lesson still resonates years later.
Yeah, and so the second story I have, same professor. He's the tough guy, he tells you like it is. So this guy talked about a consult he had done in Colorado. And in Colorado, they had some weird rule, and I don't think it exists anymore, where if you are a passenger in a car and there's an at-fault driver, you had to have contributed in some way, given him some money for the ride, for gas money or something like that, in order to sue him even for his own negligence. It was a weird rule. I've never heard of it since, but what he said was, at the beginning of the consult, he said that. He's like, here's what the law is in Colorado. So an accident happened, passenger was injured, the driver was at fault. So he'd gone to a lawyer to, seek help because he had medical bills and, wage loss and all that. So the lawyer said, let me tell you what the law is. You have to have contributed in some way in order to sue him. So, did you contribute in any way to the ride? And he said no. And then the lawyer looked down and they looked up again at the guy and said, let me tell you what the law is again. You had to have contributed in some way in order to sue this guy. Did you give gas money? Did you do, he had to preface asking him the question with the law to get it in his head. And I think it's kind of right on the boundary of ethics, but it's better to get it out there in the beginning versus getting an answer, because once you get that answer, you can't really go back on it. And then you're in real ethical trouble if that comes out. So you just kind of have to prime the client a little bit.
Great advice, great story. Here's the last story, one of mine that I did not participate in it, but I heard it, and it is a legendary story regarding a law professor at my school. But this occurred in the 1970s or thereabouts. And this law professor was an overweight, a bit of an arrogant professor that taught, I believe, contract law. So first day of class, he does an introduction to the class. And by way of background, this particular building that the law school was held in was actually leased from a Catholic college. And so they would use the rooms at night for law school night courses. And in each room, obviously because it was a Catholic school, there was a crucifix up above the blackboard behind the professor's station. And so what had happened was, and the story is, this professor told his students how difficult the course was, what was expected. I get it, that's fine. You be prepared for every class. This is going to be a hard class. There'll be hundreds of pages of reading, and we'll have one final exam at the end of the year, and you have to be ready at all times to engage in this particular class. I have no problem with that. He went a little bit out of his depth, though, with the next phrase. He said, and by the way, by the end of this course, it is so tough that you will think that the guy behind me, pointing to the crucifix, the guy behind me got off easy. Well, you would not, number one, get away with that in this day and age, insulting a whole level of religion for many, many people, and in particular the students in that class. Comparing his class to Roman crucifixion, I don't think is the answer. But this is what he did. And I think the lesson is that back in the 70s and 80s, things were a lot different. And teachers could get away with that. The other thing is that, in this day and age, you might want to just retaliate against someone that makes that type of comment toward you. And sometimes I think retaliation is good, be it maybe in a deposition or in conversation. Probably not in front of a jury, but you need to show that you are not going to stand for those types of comments, that you're not a doormat, that you're not a pushover. So I think the idea is to keep in mind that your conduct and your reputation is golden, and it will definitely precede you. Whether it's earned or not, it's your reputation, and you have to definitely protect that. So stand up for yourself, I think, is the answer to that. I think a lot of students, if they had that day back, they might have stood up and said, no, you don't. And I'm paying you for your services. We're not going to have that kind of talk, and we're not going to take it. So those are the lessons I think that you can learn from every type of law school story. those are the lessons I think that are helpful and that are definitely enduring. I want to thank Mr. Stoka for coming today, and I want to thank the audience here for listening. And remember, until next time, think like an attorney. There is no substitute.